Anthony Housefather.
Thank you, Madam Chair. Thank you for appearing today. Did you speak with anyone at Hockey Canada or its representatives to prepare for your testimony today?
Thank you for the question. I can advise the members of the committee and Madam Chair that I sent a copy of my opening statement to Council for Hockey Canada in advance of my attendance here before you. Apart from that, I did not engage with Hockey Canada in preparation for my attendance today.
Thank you. Was this the first mandate you have received from Hockey Canada?
It was the first.
Perfect. And when you were speaking with Hockey Canada during the course of the mandate, was your contact Mr. McCurdy, or did you ever have occasion to speak to Mr. Smith or Mr. Rennie or other members of the Hockey Canada staff?
I dealt primarily with Mr. McCurdy. I did have an opportunity to participate in conference calls with senior leadership at the outset. I hope that assists.
Have you ever presented your findings to the Hockey Canada board?
I think I need some clarification on your question. As I indicated, the conduct investigation, the player conduct investigation is active and ongoing. There would be no opportunity to present to the board since the investigation is not concluded. In relation to the interim report, I've indicated the date of its delivery, and this again is an area that I know Hockey Canada is asserting a solicitor-client privilege.
Okay. I appreciate your clarifying at the last hearing. Hockey Canada was very confusing about how many players participated. So thank you for clarifying that it was 10 and the reasons the others did not. But let me ask, you are a very experienced counsel. After having identified those 10 witnesses, would it be true to say you have a very good idea of who the 8 men are that are alleged to have been in that room? Not to get into whether or not anything happened, whether it was true or not, but you would have a clear idea of who the people were, would you not?
Madam Chair, this is an area that I have to be very careful in answering. As I indicated, the goal of our mandate is a search for the truth. I do not want to provide an answer in the course of these proceedings that could potentially taint the evidence from other witnesses that I have yet to hear from. Nor do I want to provide an answer that taints the evidence that will be provided to the London Police Service, who's reopened their investigation, or the NHL or NHLPA ongoing investigation. And so I do have to decline answering that question with the following caveat. My investigation is going well. As I indicated, I have the complainant's statement now, and as I indicated in my opening statement, I am well equipped to continue this investigation.
Thank you. I think what was confusing to many people was when Hockey Canada asserted at the last meeting that it did not know the identity of the 8 individuals. And it seemed highly surprising to many of us in light of the interviews that were conducted. So let me ask a different question. One of the other things that I think many were confused about was why players were not required to cooperate at the time and why no sanctions were imposed on those who don't. On June 20th, Mr. Smith testified that on the advice of our third-party investigator, we were not able to impose sanctions, presumably on those who did not participate, as they advised that we lacked due process for them. Given that Mr. Smith himself spoke to that and clearly waived privilege on that issue, would you kindly elaborate as to that answer, or whether you spoke to them about that and advised you could not require them to participate or not require them to be not allow them to be sanctioned because of due process issue?
There are two aspects to this answer, one of which is covered by solicitor-client privilege, or the claim of solicitor-client privilege. So I take your point regarding what was testified to at the prior occasion. I'm not here to give a legal opinion on the validity of that claim of privilege. And so there were discussions around that issue. I'm not authorized to disclose them to this committee, absent a direction from Madam Chair and the committee. So there's part of the answer that I cannot provide unless ordered. In relation to the second part of the answer, what I would say is, what it's important, I think, for the committee to understand is the issue of refusals had not crystallized at any point in my investigation. And that is because of the conclusion that I drew along with my law partner, Alex Smith, and supported by my law associates at the firm, that I should not interview the remaining players absent the statement from the complainant. I needed her version of events to push forward in my investigation. And so once the criminal proceedings concluded, I focused my efforts on speaking with complainants' counsel and attempting to facilitate obtaining that statement so that I would be equipped to move forward in my investigation. And as I indicated in my opening statement, ultimately by September of 2020, after 18 months of those efforts not arriving to the place that I had hoped, I closed the investigation without prejudice to reopening at a later date. And as I indicated, we are here now.